Judge Scott McAfee held a 6-hour hearing in Georgia in the RICO case brought by Fani Willis. 14 defendants are left. It was a 19-defendant case with Donald Trump being the main defendant for trying to steal the election in Georgia. Four defendants have pled guilty. The lawyers, if you will, or some of the lawyers, you had Sidney Powell, Jenna Ellis, and Ken Chesborough, and then you had the bail bondsman who also has pled guilty, and some of them are cooperating to some extent. Some are cooperating more than others. And so there's 14 of them left. There was a hearing today without the defendants, just the lawyers, to talk about many issues, the legal issues, the oral arguments on the legal issues that the lawyers are raising, and also to talk about scheduling and how big the trials should be. The judge did not rule or make any decision today and put it over for his decision. So we'll see what he says and whether any of the things that I'm highlighting are actually, you know, what I gleaned from the record and what it seems like where he's going, whether he'll actually do that or not. And one of the things he talked about was that he only wants 8 defendants to go at a time. He doesn't want some massive trial of 14 defendants. And so we'll see how that goes. But the legal arguments were really interesting. And luckily, this is all on video, right? This is live streamed. So people like me can watch and can listen. And there was one legal argument that I think is potentially something that McAfee is considering that one of the defendants raised. And the way they broke it down, because there are so many defendants, is they broke it down by issue as opposed to by person. In other words, one defense, like they presented like a joint defense argument, and they broke it down by certain issues, and each lawyer took a different issue that applied to all the defendants, if you will, or at least all the defendants whose cases were on today. So one of the issues that I thought had that Judge McAfee seemed to be interested in, and that I think is something to watch as a potential issue, is that one of the charges that many of the representatives, the Georgia state representatives, are charged with is solicitation, right? And it's criminal solicitation. And what they argued was they moved to dismiss it, and they call it a special demurrer or demurrer. It's not a term we use in New York, so I'm sure I'm pronouncing it wrong. And that special demurrer, they said, because the indictment, the counts, the way they're charged, lacks specificity, therefore, you have no choice but to dismiss these counts. Now, the government apparently can go back into the grand jury and represent and cure this defect, but so it's not fatal to the case. But I do think that they're making a little mischief, these defense attorneys, and potentially going to make it so that the prosecutors may have to represent some of the counts. So let's see. And why is it that this solicitation count, why is it that I think that this potentially this potentially has legs or has issues? And it's basically because you although an indictment is, they call it bare bones, meaning you only have to spell out the bare elements of the crime and the basic facts that support it for it to be, and that's a standard everywhere, for it to be legally sufficient. What they didn't do in this particular case is they didn't define what it is that was illegal, right? They don't know, for example, was it, the charge apparently is that they were soliciting individuals to violate their oath of office. And they said, look, they don't know which oath it is that they say that these people took, and they don't know what conduct it was that supposedly violated this oath. And he says, look, different public officials take different oaths, whether you're a police officer or or you're a lawyer or you're a public servant or you're a representative or a judge, that different people take different oaths. So how do they, and some of them take multiple oaths. So how do they know which oath it is that they took that they allegedly violated? And they said, okay, let's say with a representative, they take this particular oath and it's to violate the Constitution, you promise not to you promised to support and uphold the Constitution. He says, I assume that's the oath you mean, but how am I supposed to know? Because you didn't tell me. He said, well, okay, what exactly is the conduct? What clause of the Constitution are you saying we were soliciting people to violate? And that they lack any notice so that they don't know what they are supposed to defend against. And one of the lawyers said, look, I've done other violations of oath of office cases and tried them, but the indictment always has either the content of the oath or it's attached to it. And he said, look, legislators, are supposed to support the Constitution, but they don't know what clause, for example, that they're alleging that they solicited legislators to violate. Was it the Due Process Clause? Is it Article 2? Is it the state constitution? Is it the federal constitution? Or is it some other clause? They don't know what they're supposed to be defending against. And so how is this trying to solicit a member of Congress or a Georgia state legislator to violate the oath of office? And there's nothing in the Constitution that says a legislator can't do what, right? Like, that's the question. And so they said, look, we're assuming you're talking about, putting in an alternate slate of electors and that's what you mean. But how do we know? We're not on notice. And where is it in the Constitution that says we can't? In fact, the Constitution mandates that we put in electors, and so we're saying these are the legitimate ones. And are you talking about the Georgia one or the U.S. one? Anyway, so those are all, some of that is like, that's what you're going to say at trial. And that's going to be your argument at trial. But what they're specifically saying is the charging instrument, which is the indictment, is defective. And that with a special demur, the only option is to dismiss the count and then they can refile. And the reason I perked up when I heard this argument was because they said, look, if you were like doing a murder for hire case and, you just said, go kill someone, that wouldn't be enough, right? You have to allege who and when and how, or you have to allege something, It's just, they went back and forth on this. And Judge McAfee's questions seemed to me that he is interested in this particular argument and that he wanted the state to respond, which they did. And they said, look, he's not charged with, these individuals aren't charged with violating an oath of office, because if they were, then we would have to allege it. Instead, what they're charged with is soliciting someone to do that. And that's totally different. And the example they gave was, if you said, I want you to go beat someone up, or go take care of that person, meaning, and everyone knows it meant to rough them up or do something, but they don't know, are they going to do it by punching him in the face? Are they going to do it, with some kind of weapon? I mean, and they used that as an argument as to, look, we don't know exactly how they're going to do it. So just because they were soliciting someone to violate their oath, we didn't know exactly how they were going to do it. We don't have to allege it. And then Scott McAfee said, do you have any case law that supports that? And they did not. So we'll see what Judge McAfee rules on this issue. Like I said, even if he dismisses a couple of counts, it apparently is not fatal, because they can just go back into the grand jury and re-present these charges. But honestly, if I was the prosecutor on this case, I would feel very, very upset that my charges got dismissed. And frankly, that I had egg on my face, that it would make it seem like I don't know what I'm doing. And I wouldn't want a single win for the defense, even if it's something I can cure later. So let's just hope that the prosecution is right, that they didn't have to do this, and that the defense is just doing what defense attorneys do, which is argue their case the best that they can. But like I said, Judge McAfee was a little, he was interested in this one. And in fact, there was one moment in this that I thought was funny, which was the defense attorney was talking about a case and going on and on about how great he thought this case was. And the decision was right squarely on point, actually, to help the defense side of this argument. And then he said, oh yeah, well, this was a brilliantly argued case, by somebody. And of course, everyone knew it meant Judge McAfee. So when he was a lawyer, so he cited his own case to him, which, let's see what happens here. this was a televised hearing in Georgia. Thank God these are televised. I think all of these criminal trials should be televised so that we can watch them for ourselves and not wait for others to characterize them. But we'll see what ends up happening. I think that this will ultimately be okay. But it was But we'll see. We'll see how this goes. We'll see what Judge McAfee does. It's a window into him, though. I'll tell you that for sure. When getting to watch his thinking and his asking questions. Thanks so much for listening. I'm Karen Friedman Agnifilo with Legal AF.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.